International environmental law aims to regulate and control the pollution as well as regulation of natural resources within the framework of sustainable development, primarily through bilateral and multilateral agreements. Basically, international environmental law covers topics such as pollution, biodiversity, land, water, transborder water pollution, and also nuclear damage. In this presentation, we will explain the sources, measure of international environmental law, the principle of international environmental law, and also we do some analysis about the international environmental law. Apart from that, we will discuss the issues faced by the international environmental law.
Sources of international law. There are three major of sources international law. First, customary international law, reflected by national law, declaration of government, and interpretation of international court. Second one is soft law. Soft law used to refer non-binding law and document, but often play a significant role in creation and interpretation of principle. Lastly, international treaties. Each nation has complete control of activity within its border unless the nation agree to relinquish some control.
Fatima Azara binti Rosli 248612. In this assignment 1, I will present to you regarding major international environmental laws. There are three major international environmental laws, which is air pollution, water pollution, and also the deforestation. All these pollution is important to us because we need clean water, clean air, and also forest to give us oxygen for us to survive.
For the principle of international environmental law, we can refer to 6 principles that has been established. Majority of the principle has been established in accordance to the Rio de Janeiro Declaration 1992. For the first principle, we can refer to the principle of sovereignty and responsibility. And the second principle is sustainable development. The third is principle of preventive action. The fourth is precautionary principle. The fifth principle that has been established in accordance to the Rio de Janeiro Declaration is political principle. The final principle that we can refer to is the common but differentiated responsibility of the said country in accordance to the international environmental law.
The major principle of international environmental law is the polluter-pays principle. It is the component shaping the foundation of international environmental law. It guarantees that the organization is liable for preventing contamination. Related activities likewise similarly answerable for paying for harm performed by contamination action to the indigenous habitat. It has solid favor from economic co-activity and development as well as the European nations. For example, in Sweden, the name has been changed to Extended Producer Responsibility, where it helps the administrative staff of the government to shift the duty of the government dealing with the contamination to the organizations or companies that actually cause it. In the case of MC Mehta versus Union of India and others, 1987, the fertilizer plant had been organized amidst 200,000 people, and during the pendency of solicitation from the Supreme Court, helium gas had spilled from the plant, causing basic impeding prosperity effects on the local people. The court held that Sriram, the owner of the plant, should compensate the NDP committed, and the harm had occurred without any imprudence on the part of the court.
And challenges faced by international environmental law. There are three: population explosion, climate changes, and biodiversity loss. But today we're going to talk about population explosion. Over 25 years, there are 2 billion people in this world. From 5.3 billion in 1990 and 7.3 billion in 2015. The population has grown increasingly but slowly. Even though it's slow, but it is still increased by 81 million. The population explosion will decline water resources by 2025, and carbon emissions are also expected to increase. And increasing population also demand for food, whereby They will put a pressure on land, water, and forest resources.
Now, I will explain the development of international environmental law. Multilateral environmental agreement refers to a number of legally binding international agreements that the state use to decide on the achievement of specific environmental objectives. It can be considered as international treaty as long as the agreement was meant to be regulated by international law, which impose contractual legal obligation. Multilateral environmental agreements are signed and agreed at the international level and regional levels. So when the agreements are being signed and ratified, the parties undertake several commitments which necessary to pursue the objectives.
To summarize, we can conclude that international environmental legislation, policy, and other binding instruments have become a significant resource for sustainable governance in order to protect and enhance the world environment. There are several key actions that need to be taken in order to increase the efficiency of laws, such as emphasizing the consequences of overlapping responsibility with the state institution, increasing the public awareness of environmental issue, and also situate the need for effective domestic legislative structure.